Assalamualaikum warahmatullahi wabarakatuh and hello everyone. In this video, this time, I want to talk about copyright. Copyright for Educators 101 and this is part 1 because I'm going to do several videos on copyright. This topic I think is very important especially in the digital age. We as educators need to learn the essential basic information, basic knowledge about copyright, the do's and the don'ts, and the boundary that we need to set because we have so many materials in the internet, especially in the digital form. So we have to protect ourselves and our students. What can be used, what cannot be used. So this is what in this video I want to share. This part 1. I just want to share very basic information about copyright, and in other videos I will cover more. Okay, let's dive in. So copyright and digital content, but actually the basic principles, the basic concept and the law applies both the digital content as well as the non-digital content, the printed form, hard copy, anything. Now, when I share a topic on copyright, usually I will start with the quiz just to check the basic knowledge or prior knowledge about copyright. Then usually, as you can see here, this is one of the example of the results from the survey or from the quiz. Question number 1 here. So you can see only 13%. The red color means the students or the participants got it wrong. So only 13% got it right. So what is this question? Let's look at it. For a work, so this is a question that most people got it wrong. For a work to be protectable under copyright, it must A. be original, B. be fixed in the tangible form or of expression, C. be of professional quality, and D. include a copyright notice. Which do you think is the correct answer? A, B? The correct answer here is B, which is be fixed in the tangible form of expression. This is the very basic of copyright, understanding copyright. So let me explain in more detail what does it mean by in order for the work to be protectable under copyright. The work means anything that you create, anything that you produce yourself. That's the work. And to be protectable under the law, under the copyright law, it must first be fixed in the tangible form of expression. Now, let me explain in more detail what does it mean by be fixed in the tangible form of expression. So, copyright law doesn't protect ideas. So, you have ideas, you have great ideas, but it's still in your head. It's still not be, you have not expressed it. So, ideas cannot be protected because it's still in your head. Nobody knows about your ideas. Nobody can read your mind. Okay? So copyright doesn't protect ideas or concepts themselves. So it protects, the copyright law protects the way those ideas are expressed in a physical form that can be communicated to others. So it must be expressed, dizahirkan in bahasa, in a physical form that can be communicated to others. So here are some key points about this so-called tangible form or tangible format. Meaning that we express our ideas now into a tangible medium. The expression must be captured in a physical medium that others can perceive, others can see, others can read, others can hear For example, music. This could be a written document, a recording, a painting, a sculpture, or even computer code. As long as we have expressed it in the tangible format, on the tangible medium. So that's number one, tangible medium. Number two, it can be communicated to others, so communicable. The expression needs to be communicated to others, either visually, audibly, in the form of music, for example, or sound, audio, or through some sensory means, meaning that we can use our sensory, our eyes, our vision, our ear. We can hear, we can touch, we can see, we can read, we can basically use our sensory mediums. So that's two things, tangible medium and communicable. That's basically explain the meaning of be fixed in the tangible form of expression. Remember, if it's still here in your mind, so you're a great professor, you have great ideas, think, you have a lot of ideas. And then be careful if you share the ideas with someone and that someone express your idea in the form of writing and so on, that person can claim the copyright. Of course, it's not ethical, right? But if you sue him or her because he or she stole your idea, it's very difficult to defend in the court because you don't have any evidence showing that it's your ideas. Okay, so ideas or concepts themselves are not protected by the copyright law. For example, the idea for a novel plot or a catchy melody can be copyrighted. However, the way that idea is expressed in a book, for example, or a song, then only it can be protected because you have expressed it on the tangible medium and it is communicable. You can show it, people can hear, people can read, and so on. For example, unrecorded performances or improvisation are not protected. For example, you give one stand-up comedy, so one-time stand-up comedy, but it was not recorded. Nobody recorded, so it's not captured in any tangible medium. And probably when you do the stand-up comedy, you communicate to your audience, but then it's not captured in a permanent form. So it wouldn't be protected by copyright unless it was recorded. So the communicable part or written down somewhere. So you have a permanent record. Okay. So these are the things that we have to really register in our mind about what qualify, what can be protected by the copyright law. So again, anything that we express on the tangible medium, a song written in the sheet music, ideas written in novel, ideas, story, and so on, written in the tangible form, in a book or somewhere, painting on a canvas, or you can save your work on the storage media. It can be any form of storage media on the cloud, on the computer, on the disk, and so on, as long as you have saved it as a permanent record. Okay, so that's basically very basic things that we need to understand about copyright. But I have not defined yet what is copyright. What is copyright actually? So we have to understand that for a long time, people are so familiar with this symbol, C. When you open a book, on the inside page, you will see C and something else. So C shows or indicates that the work, the book, whatever, is copyrighted, meaning someone has exclusive right. So we will define what are the exclusive rights, what are the rights, what are the exclusive rights. So when we say previously, copyright was binary, meaning that either something or a piece of work is copyrighted or copyright free or public domain. We call it public domain. So here C means all rights reserved. Reserved to whom? Reserved to the owner, reserved to the author, reserved to the creator. On the other hand, on the other extreme, we have public domain, no rights reserved. I repeat, this one, C, all rights reserved, public domain, no rights reserved. So how does something become no rights reserved or become public domain? This I will explain in later on, or maybe in another video when we dive deep into understanding about copyright. So previously it was all rights reserved or no rights reserved, copyright or public domain. But now in the digital era, and this is where in the next video I will dive in deeper into this, something called Creative Commons or CC. So we have C, then we have now CC, and it is somewhere in between. C is all rights reserved, public domain PD is no rights reserved, but Creative Commons are some rights reserved. Some rights reserved. So now, in order to understand what rights actually are reserved fully, what rights that we can reserve some and we can release or we can waive some. And public domain, no rights reserved. Okay, no rights reserved. So we need to understand first what are the rights to the owner of the work, of the material. Well, again, we are very familiar with this one. Any piece of work, any book, for example, when we always see this copyright C 2010. So C means all rights reserved to this publisher, in this case, John Wiley and Sons Incorporated, all rights reserved. Published by the name of the publisher and some more detail. So copyright simply means it's a set of exclusive rights. What are these exclusive rights? And these rights are granted to the author or the owner or the creator. And the exclusive rights are these: original work, including the right to copy. The rights are including the right to copy, the right to distribute, the right to adapt the work. These are at least three. Yeah, the right to copy, the right to redistribute, the right to share, the right to adapt the work. Okay, let's see more. Okay, right to produce. Right to reproduce. So if I'm the owner of the book, I'm the author of the book, I can make many copies of the book. I can photostat the book as much as I like. I have the exclusive right to reproduce, to make copies. So example, a scan of original work. The right to create a derivative, meaning that a different version of the work. Okay, a derivative work is a variation or transformation of pre-existing work. Example, creating a sketch of an existing painting. So I have a painting, but I can also create a sketch or a different format, different visual format of my own work. I have the exclusive right to do that. Creating a silhouette created from a photograph, from the original photograph, I create a silhouette of the photograph. The right to distribute. The right to distribute a work includes the right to sell, transfer, rent, or lease the work. Example, selling prints or posters of a photograph. I can do that. I can make a profit. I can do a business from my work. I have an exclusive right. All rights reserved to me. Rights to display publicly. The right to publicly display work to public audience. So, for example, displaying a photograph on a website, displaying my arts painting in the museum, in the gallery. The right to perform publicly. the right to perform a sound recording to public audience. For example, playing a song on internet radio service. The right to create a derivative work. The best example, or one of the good example, is novel. For example, Harry Potter novel. So, who is the author? Forgot the name. The lady, she became a millionaire or billionaire, because she has the right to make a movie from the book, okay, and other spin-off from the book, so become a billionaire. Okay, so these are when next time when we hear the term all rights reserved, which is the C symbol, indicate or symbolizes the copyright. These are the rights reserved. When it become public domain, and how does a work become public domain? Two ways. One, we create a material, then we declare. Upfront, we declare, I declare this material to be in public domain. Use it as you wish. You can even sell it. And you don't even have to put my name. You don't even have to acknowledge me. That's public domain. That's one way. We declare. As the owner, you can declare. Why? Well, you are very generous. You just want to share your work. Okay. For example, if you go to a website called Pixabay, Pexels, Unsplash, these are the platform where photographers can share their work, and they have to declare, they have to agree on the terms. The terms is when you share your photograph here, your image here, you will become a public domain. So, I agree to that terms. That's one way. Another way how things can become public domain, when you create something, automatically the copyright law will protect you. You have the copyright. You don't even have to register. Or the law give you the right to all the exclusive right. And when you pass away, that copyright still there, still valid, and you will keep the copyright even after your passing, after you have died. 50 years under Malaysian copyright law, 50 years after you die, only the copyright will expire. So the duration of the copyright according to Malaysian copyright law is during your lifetime and 50 years after your passing. Okay, so after that it will become public domain. There's two ways at least how things can become, how any piece of work can become public domain. So no rights reserved. Anyone can use it as they wish, and they can even actually, and when they use the public domain material, they don't even have to acknowledge it. Although good practice is, okay, just give the credit, but you don't have to. That's public domain. And of course, something in between we call Creative Commons, where some rights reserved. I will elaborate that in the next video. So I just want to explain here that when we talk about copyright, it's only one of the at least four main types of intellectual property, IP intellectual property. And most of the time we talk about copyright, but there is also patent. Patent protects inventions, new processes, machines, or compositions of matter. But copyright protects original works of authorship and grant the copyright holder exclusive rights, which I've just explained just now, to reproduce, distribute, adapt, and publicly display the work. And trademark, TM, the TM. Trademarks are recognizable symbols, words, or phrases that distinguish the source of a product or service from its competitors. And then, last but not least, trade secret. Trade secrets are confidential business information that provides a competitive advantage. They can include formulas, customer lists, algorithms, or manufacturing processes. So if you want to learn more about copyright, one of the, I would say, the recommended sources here is the official portal of Intellectual Property Corporation of Malaysia, or MyPO, my IPO. And you can find a lot of information on copyright here, and on trademark, patent, and so on. Industrial design is another one on this website. And if you want to register your copyright, which is not really necessary, but now it become a common practice, especially in Malaysia now. You can go to this website and you can find more information. There's an online registration and so on. And you have to pay around 60 ringgit or something. And you can get the copyright registration done in 1 day. I think in 1 day. Okay. And finally, for this video, I want to highlight to you that on my IPO here, you can find under the resources, I think somewhere, I can't remember now, where you can download this free educational comic. And this is actually very good if you want to educate your students. I mean, educate ourselves first, and to educate our students, and ask our students also to read, so that nobody can give an excuse that we don't know, we are not aware, you don't understand, because there are so much resources there or out there on copyright. And I hope a series of video that I'm going to do on copyright will help educators especially, and also students. All right. So I think that's about all that I want to share in this video. I hope I've given value for your precious time, and please feel free to share the video to your students and to others, so that we can share this useful information and educate ourselves, educate everyone about the importance of copyright, and don't get ourselves trapped or be sued in the court for copyright infringement. So that's all. I'll see you in the next video. Bye-bye.